Assalamualaikum warahmatullahi wabarakatuh to Miss Masria. Today, I want to present about newspaper cutting report AGR255. My name is Nur Nasira binti Muhammad Fazli and I'm from 81104D. The title for the newspaper's cutting is Employers Must Not Ignore Labor Requirements Despite Relaxation Plans. So, the content is, the first one is summary, key issue, solution 1, solution 2, solution 3, and lastly conclusion. And I want to tell you about this summary, which is the foreign worker employment relaxation plan has been implemented by the Malaysian government to expedite the approval of quotas for foreign workers. Human Resources Minister Wisiwa Kumar has urged employers to ensure compliance with labour standards such as monthly salary payments and contribution to the Social Security organizations also. He also urged employers to apply for a quota for foreign workers under the plan to relax the employment of foreign workers based on actual need. He also urged employers to ensure that the documents to support the quota application are authentic. The plan for relaxation of condition on migrant worker recruitment covers manufacturing, construction, plantation, agriculture and services, restaurant-only sectors and subsectors. So I'm gonna tell you about the key issue, which is neglect of labour standards aspect by employers. Department of Labour in Peninsular Malaysia, JTKSM, and the Immigration Department will keep an eye on labour standards. 6 to 7 months after the quota approval data, it will be monitored. This was essential to protect the nation's reputation and credibility without threatening the welfare and right of workers. Under the plan to relax the employment of foreign workers, employers were urged to apply for a quota for foreign workers. The plan for relaxation plan of conditions on migrant workers recruitment covers manufacturing, construction, plantation, agriculture, and sectors and subsectors. The employers must maintain on the basic aspect of labour standards such as monthly salary, payment to workers, including the minimum wage implementation and contribution to the Social Security Organization (SOCSO). And majority of labourers are treated like modern slavery by the employers as employers failure to provide accommodation conducive to people's home, while the number of foreign workers employed is huge. Every time a raid operation is carried out, it is found that failure to comply with Workers' Minimum Standards of Housing and Amenities Act 1919 Act 446 is the employer's main fault, which is the failure to provide accommodation conducive to people's home, while the number of foreign workers employed is large. The solution is document the issue about the mistreatment. Referring to the Employment Act 1995, if the worker suspect that the employer is disregarding labour rules, keeping a record of any instance where they observe them being violated is a crucial step. If they need to report the problem to the employer or a government agency in charge of enforcing labour rules, this step will assist in developing a compelling case. In addition to documenting specific instances of labour standard violation, it is also helpful to keep track of any patterns or trends that workers notice in the workplace. Keeping a record of labour standard violations can be done in several ways. It is whether the worker choose to keep a journey or logbook, take a photograph of unsafe working conditions, or save email or other documentation related to the issue. It is important to keep these records in a safe and secure location and to make sure that they are easily accessible if need to report the issue to the government agency. The employees can strengthen their case if they need to report the matter to the nearest labour department by keeping track of this infraction. which also helps to guarantee that the employers is held responsible for their conduct. For solution 2, employees file a complaint. After every other options have been explored, filing a complaint with an agency of government in charge of enforcing labor rules is a serious step that needs to be taken. This phase entails bringing the problem to the notice of a third-party agency, which is the government, that has the power to look into and prosecute employers that violated the labor laws. Most nations have government organizations tasked with upholding labor rules and making sure that companies follow them. These organizations such as Occupational Safety and Health Act 1994 OSHA and the Labor Relation Agency LRA usually have a procedure for submitting complaints, which may entail completing a form or sending a written complaint that describes the specific of the infraction. And it is crucial to keep in mind that submitting a complaint to a government body can be a drawn-out and complicated procedure. So workers should get legal counsel if they are thinking about doing so. However, submitting a complaint may be the best line of action to defend their rights and those of their co-workers if the employer is disregarding labor norms and endangering the safety and the well-being. Employers who violates the law can be fined not more than 100,000 ringgit Malaysia and imprisonment of not more than 5 years or both. Solution 3 is report the mistake to the Department of Labour Peninsular Malaysia, JTKSM. The Employment Act 1995 protects foreign workers who are legally employed in Malaysia. Employees must receive payment at least once a year and it must be made no later than 7 days and following the end of the pay periods. The Employment Act of 1995 is one of the many labour laws in Malaysia that must be enforced and administered by the Department of Labour Peninsular Malaysia, JTKSM. One of the main pieces of law that controls the employment relationship in Malaysia and lays out the essential safeguards and rights for workers is the Employment Act 1995. JTKSM enforced the Employment Act 1995 by ensuring that employers comply with its provisions. Some of the key areas that JTKSM enforced includes minimum wage, working hour leave, termination, and many more. The Department of Labour Peninsular Malaysia, JTKSM, helped with investigating the complaint, providing legal assistance, mediating disputes and providing support service. And lastly, conclusion. The best solution for me is solution 3, which is report the mistreatment to the Department of Labour Peninsular Malaysia, JTKSM. This is because by reporting the mistreatment to the Department of Labour Peninsular Malaysia, JTKSM, the process is more detailed and help with investigating the complaint, providing legal assistance, mediating dispute, and providing support services. This surely will help those foreign workers that has been mistreated by their employers and their job opportunities will be open wide without any neglection.